Folks, I'm starting right now, although typically what happens is people keep rolling in for the next 15, 20 minutes. There'll be a bit of a disruption from that point. I would suggest that you come forward and sit and let the stragglers come in at the back, that way, because we are officially sold out. I mean, the capacity here is 100, but we sold 120, knowing that when the ticket is freebie, people just check in and then they say, oh, okay, well, I'm caught up in traffic or something like that, okay? Okay. First and foremost, I want to tell you what's going on in case you think there's been a bit of a lull since our last workshop in May. You might have all seen that sizzling summer activity email from me. And we have had 22 startups who've already signed up. That means they're ready to go, of which we disqualified 4. I think 4, 2 or 4. We disqualified. One was out of the area. Number 2, a guy was starting up a service company, and that's not our goal. We are trying to educate the people who are developing product companies. That's what Silicon Valley is all about, not service companies. So we've been doing that, and cohort number 1, I have got Sudhir Kadam here from IIT Kharagpur. He will just tell you in just a short clip of a minute or two what he's been up to on this, okay? And I want to tell you all again, and I'll say this again, we've started an IIT LinkedIn group, IITSTARTUPS. By mistake, I think we first called it IIT Startups Bay Area because the IIT Startups were not available, but then we found out one of our volunteers had actually locked that name, a lady called Rekha Pai, but she's one of our team. So she handed over the admin controls to Sudhir, and Sudhir is running that. But if you sign into IIT Startups, then you will be continuously abreast of all the information that's going on, okay? Then for this evening, we have Rajesh Aji. He's an alumnus of IIT Bombay and also did a law degree from UC Berkeley. Okay, so he's a lawyer come engineer, attorney come engineer. He's going to be the moderator for this evening, and he will introduce the speakers, the panelists. Okay, and without any further ado, let me hand over to Sudhir. He will just give you a brief clip about what's going on.
Thank you, Manishi. I'll just give you a brief overview of what we are up to with the first cohort. First cohort is about 17 startups. 3 are in the space of IoT, 2 in fintech, 2 in educational technology, 2 in cloud technology, very interesting space that they have got into, some very, very unique startups we have there, and 2 in health tech. And all of the startups have some form of AI and ML around them. Okay, so we have now brought in another group, which is an AI ML forum run by Dr. Tushar Kant. And we are now working closely with that forum so that we can have some sort of a cross-pollination with that team, okay? Because they have been covering subjects like voice technology, deep learning, and so on. So we have startups which are in retail technology, which are in deep learning for images, which are in biotechnology, and so on. We have 7 startups from IIT Madras. We have 4 from IIT Kharagpur. We have 2 startups each from IIT Kanpur and IIT Mumbai, and 1 from Delhi and Roorkee. So that's the breakup we have currently. We have closed the cohort number 1 now, and we will open up the cohort number 2. So the applications can keep flowing in, and as we open the new cohort, they will all go into the new cohort there. What we are going to do with cohort number 1 is we are going to now do an internal review of the pitch decks that they have made so that they are investor ready. And these pitches are going to be reviewed internally by all the mentors, and there will be discussion amongst the various startups. After that, we will get them ready for demo day. The demo day will comprise of an investor panel, which will comprise of people from corporate ventures like Cisco and so on, people from the tier 1 VCs, as well as a lot of angels, and angel funds, they will be present over there, and this will be an opportunity for them to present. We are also planning to go a step ahead. Okay, that is, Monish's plan is not just an early stage startup, but we want to now look at level 2 startups, which are post-seed startups, okay, which are in dire need of scale-ups they are in need of corporate connections as well as VC funding, the Series A startups typically. Okay, so we are going to open a separate cohort later on during the year, which will address those issues also. So if you have any questions, reach out to me. My name is Sudhir Kadam. I'm IIT Kharagpur, 1976 graduate. Thank you.
Okay, folks, I want to tell you there's no deadline for you to submit. Come to us when you're ready. Don't rush, because this is a continuous activity as far as we're concerned. We are going to be around for years together. We are going to make this a continuous thing. And as he mentioned, we will do this. Apart from this level 2 cohort and the level 3, which is people who are near exit, we will be doing that. We are also going to try to arrange later on, even when we don't have workshops, a monthly get-together where all of us can meet, because I found most of you are very keen to meet with each other, to exchange ideas and all that. We're going to also do that once a month. So with that, let me cut it short and hand over to Raj.
Thanks. I think I have a mic.
Oh, you got a mic.
Yeah.
Okay, if you have any questions, when Raj allows it, just raise your hand and I'll bring the mic to you. The reason why you need to speak into the mic is because we are video recording all this, and we've recorded all the workshops. They are for transmission worldwide. I mean, India institutes are getting it, and other regions like Boston, Washington, they also, when they ask for it, they will get that. Okay, thank you.
Thanks, Manish. Let me start by introducing the panelists. I'd like to thank Sherman and Lara for joining the panel. I've known Sherman for a long time. Sherman's a partner at DLA Piper, which is one of the world's largest law firms. Sherman is also an engineer and a lawyer by training. He got his engineering degree at Columbia and a law degree at NYU. Practiced at a number of law firms before spending over a decade at Cisco Systems, where for a while he was my boss. And he was the general counsel for Cisco, based in Shanghai, for the BRIC countries, emerging market countries. His practice now focuses on technology transactions, IP protection, and he would add that component to this discussion. Lara Anthony is an attorney with Fenwick & West, which is hosting this event tonight. And Lara's practice, Lara went to Michigan for law school. And Lara's practice focuses around, emerging companies, corporate formation, M&A, venture financing, and other types of corporate transactions. I'm the general counsel. I'm the general counsel at Bill.com. Bill.com is a late-stage fintech company. I went to IIT Bombay several years ago, and went to Berkeley, as Manishi mentioned, for law school. Practiced at a number of law firms before going in-house, and for the last 15 odd years, I've been in-house, and my practice has focused around financial services regulations, payments. Before that, in entertainment law and enterprise technology. With that, I'll get started. For today's panel. The format that we thought about was, what happens when you are an early stage startup, and what are the types of questions that come up as you're thinking through how you're going to get your business started. Once you get your business started, what are the things that you need to think about? So it's really designed around early stage companies and common corporate and technology related questions that founders and employees have for lawyers. And so it's a Q&A format. I'll ask Lara and Sherman questions and have a discussion. Towards the end, we'll open up the panel for audience questions as well. So, Lara, first question is, you're thinking about starting a company. You have a great idea. You want to get started. You want to form a company. What are the various options that are available to you? What are the various corporate structures? And can you talk about, what are the pros and cons related to that?
Sure. So, as I understand it from Manishi, the main target audience here is product companies, particularly that are looking for venture capital financing, venture capital funding over the years. For that model, the Delaware C Corporation is by far the best way to go. If you incorporate in a different state or with a different corporate structure, a different tax structure, at the time that you go to seek venture capital financing, you will likely need to convert into a C corporation, and at some point you'll likely need to reincorporate in Delaware. Why Delaware? Delaware made its corporate laws very business friendly, and so businesses across the country have taken advantage of that, and the effect has snowballed. So Delaware is the state of choice for incorporation for any most large companies that are going to practice across state borders. They're going to have a business that's not going to be just in one state. So on the contrary, if you have a small enterprise here in the Bay Area that is, you're going to open a restaurant or something, no need to go incorporate in Delaware. That's not necessarily the right structure. But for this audience, a Delaware C corporation is probably the right way to go. There are certainly alternatives. C corporations are subject to what's called double taxation. So corporate profits are taxed, and then again, when profits are distributed to shareholders, there's another layer of tax to those shareholders. Alternative corporate structures, such as partnerships or limited liability companies, collapse that, and there's only one layer of taxation. Limited liability companies are taxed like a partnership. So the owners of the partnership receive the profits or losses of the business every year, and so there's just one layer of taxation. It's called pass-through taxation. So that's a structure that many business people consider when they're starting out in forming other types of businesses. So a services firm, like a law firm, for example, probably has that type of corporate structure. LLCs are very popular if you're entering into business with some business partners and you want to share in the profits and losses without double taxation. However, like I said at the beginning, if you're building a product company and you're going to seek venture capital financing, you're probably going to want to go for a Delaware C corporation, despite the double taxation issue, because the venture capital firms don't want to invest in limited liability companies or partnerships. Most of their LPs, most of their limited partners have restrictions against making investments in those types of entities. So if you've incorporated as a limited liability company, initially, when you get that first Series A term sheet, part of it is going to be, you're going to need to flip into a C corporation at that point. There are other advantages to C corporation status, such as QSBS, qualified small business stock, exemptions that are available that are not available if you're an LLC.
Would you ever consider incorporating overseas, like in the Caymans?
Great question. I certainly...
This adds a lot of complexity to administration
complexity.
and costs, which you wouldn't want for an early stage company.
Exactly. For an early stage company that's starting out here in the Bay Area, there's quite a community here, as you've probably gathered, around startups and venture capital financing and backing of those startups. So there are, the National Venture Capital Association has a website with model legal documents that anybody can go and review and use. And there's been quite a lot of standardization in the industry around what model terms are, what best practices are, and there's a lot of cost efficiency and just simple time efficiency that can be achieved by sticking with the sort of more plain vanilla or widely accepted terms in the community here in Silicon Valley. So I think, yes, going to the Caymans might have tax advantages in some cases, but they might not, especially for an early stage company, outweigh the benefits that a company can gain by sticking with what's normal, if you will.
So what I'm hearing is, you're an early stage startup, there's so many things that you need to worry about. The corporate structure, legal entity structure is keep it as simple as possible. Go with what's tried and tested. Go with the C corp, and a Delaware corporation.
Yes.
The only thing that I might add to that is, and I agree very much that in the beginning you want to keep it as simple as possible. A lot of it is sort of the stage of the company, and the advantages of, let's say, going with Cayman really come in if you do the move before the valuation of your IP gets really high. So typically the way IP gets valued is, they look at things like revenue, other factors, and if your company is really doing very well, at the right stage you want to think about moving it to a Cayman structure potentially to avoid the exit tax that the U.S. will impose on the IP that's being moved out. So very much a stage of life for the company issue.
Great point.
Great point. So Laura, once you've incorporated your company, you are 2, 3, 4 founders. What's the next thing that you need to do? How do you allocate the ownership of the entity that you've just created, and how do you memorialize that? How do you think about stock vesting? Can you speak to that?
Sure. So this would actually all happen concurrently, ideally. The incorporation and initial issuances of stock should all happen at the same time. Key pieces of it would be to make sure that you are assigning any IP that has been created prior to the date that the company was formed to the company. So if you've been creating some business plans, thinking about your idea, maybe even writing some code, whatever it is, prior to actually incorporating, it's absolutely critical that in connection with issuing your founder stock, founder common stock is what we typically issue, that you are assigning all IP that you've created for the company to the company at that point. The mic is coming in and out. So the equity still not. The equity in the company is
Still not on.
is not going, is it? Is that better?
Better.
So as far as dividing up the equity in the company, that's typically a decision among the founding team. So it's very much a decision among the founders to what extent, how you're going to divide up the equity. If you start with a whole pie, for example, when you found the company, did one member of the team contribute sort of more of the is bringing more to the table, or sort of the lead founder, maybe that person gets a bigger chunk of percentage-wise of the company than co-founders. Did somebody join the team a little bit later? Maybe you had 2 people who were starting out working together for a year, thinking about things and developing the idea for the company, and then somebody else entered later. There are a number of different ways that you can address how different people bring different things to the table. Say you decide you want to go, you have 3 founders, you want to split 3 ways, but like the last example, somebody joined later. You can kind of make things equal by giving vesting credit for the 2 founders who were working for a year already. They'll get their shares, the vesting schedules on their shares would date back to when they began working for the company, whereas the founder who joined later, you would start their vesting schedule when they began working. You don't have to impose vesting on your shares when they're issued, but again, when you get to that first financing, when you're dealing with a venture capitalist, they're going to say, hey, we want to make sure you're properly incentivized to stay with the company and keep building. So if you haven't imposed vesting on yourself from the beginning, they're likely to impose it later, and they might not be as generous as you would have been to yourself if you'd done it from the beginning. So the most common vesting schedule used here in Silicon Valley is a 4-year vesting schedule. Typically, shares would vest monthly over 4 years. So if everybody's getting, say, 100 shares, 25 would vest each year on a monthly basis. With founders, it's common to begin the vesting right away, so on a monthly basis from whenever they began working on the company. When you begin hiring employees later, typically a cliff is imposed, which means that the person only vests once they've been with the company a certain amount of time. So the typical vesting schedule for an employee is 4 years monthly with a 1-year cliff. So the person has to be there for a whole year before they vest in anything, and then on the 1-year mark they get that whole first quarter of the grant. So the first year of vesting, it's 0, 0, 0, and then on the first anniversary of their hire date, all of the shares from that first year vest at once, and then it's monthly thereafter.
So what happens when, say you start off, you have 3 founders, and you're working at it. You got your equity divided up 3 ways, and then 6 months down the road, one of the founders decides that, look, this startup is not working for me. I want to go back and find a regular job. What happens to the vesting? Does vesting protect you? How does that play out?
Perfect. So the vesting is exactly what aligns the company's interest with the service providers. So if, in this example, somebody decided to leave after 6 months.
Put the transmitter on this side, because every
Okay.
time you touch the cable, you can put it right behind.
Okay.
There we go.
That should solve it.
I think that should solve it.
Okay. Thank you.
Thanks.
So in Raj's example, if the employee leaves after 6 months, the vesting will stop when they leave. So that means they get credit, they get to retain the shares that vested during the time that they were working for the company, but then when they leave, the vesting stops. So with founders' equity, typically that means the company will repurchase the shares that were initially purchased at cost, and later with service providers, usually the shares are issued as stock options, and upon when the person leaves, they then have 90 days usually to decide whether to purchase the options or not and to exercise the option.
Great, thanks. What happens when so you talked about them, you talked about stock options, granting the founder stock options versus granting them, selling stock. Mm-hmm. If you're vesting, are there tax consequences? Do you pay taxes at each time it vests? How does the tax work?
Sure. So when you're doing an initial issuance of founder stock, there's no tax at the time that the stock is issued, but you would be taxed on any gain when you sell the stock. So years down the road, hopefully you've been acquired. Certainly there would be tax on the gain, and if you bought your shares right at formation, the purchase price you would have paid at that time would have been very, very low. So there'd be quite a bit of gain, presumably. Again, circling back to the QSBS point earlier, if you've held your shares long enough and met certain other requirements, there's exemptions, I think up for the first 10 million of gain is exempt. So that's a wonderful thing to be able to take advantage of. As far as stock options go, there are 2 different types of stock options. There are incentive stock options, often known as ISOs, and ISOs work kind of like the founder stock that gets issued at incorporation. There's no tax when the option is granted. There's no tax as it vests, and upon exercise, there's also no tax, but there would be tax when you sell the shares on that gain. On the flip side, the other type of stock option is a non-qualified stock option. The ISOs, the incentive stock options, are only available to US-based employees. So if you're a contractor or you're based overseas, then the non-qualified stock option is the only one available, and that one is taxed on exercise, and the company needs to withhold on that as well.
Any other filings that you need to do? Can you talk to
Yes.
when you the timing of those filings is critical.
Yes.
Can you speak to that?
Great point. So everything I just said about tax is subject to proper tax filings, including an 83B election. So if you are getting founder stock that's going to vest over time, it is imperative that you file an 83B election and you file it on time. There's only 30 days to get the election filed from the date that you purchased the shares. There are no exceptions. There are no extensions. If you blow it, and the tax consequences are very negative. In that case, you would actually be taxed as the shares vest. On each vesting date becomes a taxable event.
And then you have a situation where you have stock which is vesting, you're paying taxes, you're not able to sell your stock, and you're paying taxes.
Yes,
Is that right?
exactly. So filing an 83B election essentially says to the IRS, please tax me today on the spread between the fair market value of these shares and the price I'm paying for them. On day one, when you purchase the shares as a founder, the spread is zero. There is no spread. So your tax is zero, which is why it works beautifully and you don't have to pay tax on those shares.
I'm going to try mine for now. Maybe that might work better.
You can use another mic.
Yeah,
Is
maybe
there another one?
a handheld mic.
Here, I use this.
Thanks. So we just talked about a number of issues related to, if you have an idea, how do you form a company, how do you issue stock, what kind of filings that you need to do. We talked about vesting schedules. If there are questions related to these topics, we'd love to take them now. Yes.
So my question is about the formation, right? So you guys said, okay, like as C Corp is the best option. And on a timeline basis, where does that fall compared to like actually filing a license? Like, do you have to get a license in the city of San Jose or the Santa Clara County? What are the aspects there?
So when you incorporate, assume you incorporate in Delaware, you would concurrently file with the state of California to transact, assuming you're based here, you would concurrently file with the state of California to, as a foreign corporation, to be allowed to transact business here. That means you'll end up paying tax in both states. And yes, there are, gosh, I can't say I get questions about local licenses very often.
But various cities have city business licenses, and that often comes up when you're doing a first round of financing. Your investors will want to make sure that you have all of the appropriate licenses, but that's not usually a big task, or it's not something that you would attend to right away.
But so which one do you need to do first?
You would incorporate. You got to exist as a business, and then you file a license in your local jurisdiction.
One small point. If assuming you're working with a law firm on your incorporation, all the documents that you would need to prepare and file would usually be prepared concurrently as one big package, and you would want to take a look at everything, make sure it matches your expectations and desires, and then once you're signed off on all of the documents, you would proceed with filing the charter, the certificate of incorporation in Delaware, and as soon as that comes back from the state, then you would execute all the other documents, form your board of directors, adopt your bylaws, issue the founder common stock. There are some securities filings. Every issuance of a security stock needs to have an exemption from registration with the SEC. There are exemptions available for these types of issuances, but they require a filing of a piece of paper with California. But yeah, typically you would kind of prepare everything all at once and execute it all together.
Sherman, what about trademark issues? If I want to start a company, and what kind of trademark or domain name issues do I need to think about?
Yeah, so so trademark is largely based on usage, right? So there are two ways to get a trademark. One is by straight usage, right? That's sort of the common law trademark, and the other is by registration. And by registration, you still at some point have to use the mark at some point in order to preserve your trademark. So I think typically for new companies, they're usually, particularly for product companies, I think they're usually a little bit more focused on getting the product out, And so typically what they would do is they would look at a trademark at the right point in the development cycle when you're actually getting ready to release a product and it really matters. There's not much point in getting it too much earlier. Now, if you wanted to name your company, right, that's something which you may need to decide earlier on, and that's the other rationale for doing it. But
yeah, that's what I meant. I mean, what if I wanted to start a company as Nike Engineering? Would I be concerned about that, or the domain name? That's what I was referring to.
Yeah, that's a good point. You probably do want a domain name relatively early. The way that trademarks work is that when you get your mark, it's within a specific category of usage, and the trademark office has all these multiple categories of use. So, for example, Nike has their trademark, I'm sure, for apparel, shoes, probably certain types of electronic devices. It doesn't necessarily preclude you from registering a similar name if it's not in a category that's very similar to Nike, for example.
Yeah, so that's something that we deal with early stage companies. As you're incorporating, you need to make sure that the name you want to use is available to be used in your corporate name. So we can do checks in Delaware, California to make sure that the name you want to use can be used. And then sometimes you want, if it's really important to you that you're able to use that in branding as well, you might want to consult a trademark attorney to see if the particular name is also available from a trademark perspective.
It's amazing because when you look at the number of 4, 5, and 6-letter names that have not been used in the tech industry, it's very small. So.
I had a question on the 83B election. Is there a reason why the election is there? Because it seems like everyone would always want to do it, and it's like people would trip up on it. But is there any advantage to actually not doing the 83B election?
People do trip up on it. I don't pretend to be a tax attorney and know the why behind the 83B election. I think it's, the default is that you will be taxed as the restrictions on the shares lapse. And so it's an election that's available with respect to shares that are unvested, and it's just an opt-in. You can take advantage of, this tax, not loophole, but this option in the tax code. But yes, people do screw it up. It's very hard to clean up, especially if vesting starts right away. So it's just something to keep in mind as you're forming and issuing shares. Make sure you're working with an attorney. Make sure it gets done right. It's worth it to pay $5,000 up front to make sure that it's all done properly, so that you're not facing a big tax bill later.
Yeah, so long as you are the value that you're paying for the stock and the actual fair market value of the stock is the same, as Laura said, there's no downside to not filing an 83B.
Yeah, I would even say if you're, we even encourage folks who are international to file if for whatever reason they're receiving shares and an 83B election is even available, even though they're not in the U.S. If they decide to move to the U.S. during their vesting period, if they have filed that 83B election, then it's good when they move here.
Lara, there's one question. Many of these early stage startups are working a day job, and in the evening a bunch of friends get together and they're cooking their idea and they're working on it, advancing it. So at what stage are you saying that you should incorporate and do all the steps that you outlined? When do they need to do it? When they jump off employment, or while they're working for somebody else? And
so this is where Sherman
it's common practice in the Valley.
This is where, yes, we will overlap on this one, but you want a clean break from your prior employer before you form your new company. You should not form your new company while you are still employed at the other company. If you're moonlighting, doing some work on the side, working on your project nights and weekends, make sure you're working nights and weekends. You're not working during your business hours. Make sure you're using your own equipment. You're not using your employer-provided laptop and cell phone and so forth. And make sure that you have a clean break. you have ceased employment, you've quit before you form that new company.
We'll get into that in the subsequent topic. Just want to get into some amount of detail on how do you protect your IP, how do you make sure your IP is clean. But I just wanted to make sure, see if there are any questions related to formation of a company and issuance of equity.
Sometimes we get requests like from contributors that issue stock to their LLC instead of themselves for tax purposes. So is there any disadvantage of issuing stocks to a company instead of
So you're saying if a founder has his or her own LLC, would you issue stock to the LLC rather than the founder?
Yeah.
I would say that if you're going for an investment, that wouldn't be looked upon as very favorably if a founder is holding stock through an LLC rather than as the individual, because if the founder leaves, how do you attach vesting to it?
It is tricky. I do see it sometimes. Typically, the stock will be issued to the individual, but sometimes I see people transferring their shares to a trust, for example, and you've got to be very careful about it because you want the vesting schedule to continue and attach to the actual service provider, like Raj said. So it can be done. It's not very common, and you need to make sure it's done properly if you're going to do it.
Yeah, so I had a question on incorporation. Are there any pitfalls associated with incorporating your company earlier as an LLC, and later when you are ready for venture capital, you have proven the market, maybe you have customers, then incorporate it into a C Corp. So that way you avail the tax advantages in the beginning, and then you can do a C Corp when it's needed.
Apologies. So there are some costs associated with the conversion, obviously. The reason that people don't typically do that, excuse me, is at the beginning, most of these companies are operating at a loss. So you're not passing through profits, you're passing through losses. Now, if you have, other gains, other income that you can offset, you can use your net operating losses, your NOLs. Some people do choose to do that, and I have had companies that have elected to go that route. But for most of the companies that are going to be seeking venture backing, you're operating at a loss, not a profit. So that's why it's not advantageous and not done.
I had a question about assigning IP. You talked about.
Can you hold off can we hold that question for the next topic?
Sure.
Thanks.
Anybody else?
I think Raj, move on to your next topic. Then we'll take on.
So you've got a set of founders. You've incorporated your company. You've filed all of your local business licenses. You have issued equity to the founders. You have stock option agreements. Now, how do you? A question for Chairman. How do you then make sure that your IP is clean? The company, you're getting started. How do you make sure that the IP that the founders bring to the company, you're hiring consultants? How do you make sure that the company owns the IP? You're hiring employees. How do you make sure that the company continues to own the IP? What about IP that they have developed prior? How do you deal with those type of issues? Because it's a technology company. How do you make sure that all of those assets remain within the company?
Yeah, I mean, it's a great question, and I think maybe the context should be that, if you're a technology company, at some point, if you're looking to be acquired or you're looking to, or you generate significant revenue, these will be key questions. I know in the beginning in a startup's life, it's easy to overlook these things because you're scrambling and trying to get everything done. But for a technology company, I think IP is one of the most important things that you need to think about because it really is the long-term future of your company. So typically, when I see startups and pre-public companies in general, all the way through the life cycle, through an IPO, and then into a mid-stage company, the two biggest sources of IP problems, one is people coming in, and the second is your deals with partners and customers. So on people coming in, Raj has pointed out, if you're the founder, there was a question raised earlier about how people brainstorm and at what point do you incorporate. So what's really key is, from a practical and from an IP perspective, is you really do want that clean break. Because if you're employed, every tech company has an employment agreement with all of their employees that says that the company owns all IP that you create. Now, typically, it's within your scope of work, within your general area of expertise. But for most people, that's the kind of company you're going to start. Not too many people in the tech industry are going to be starting sneaker companies, for example. So you really do want that clean break. The other practical aspect that I would say is, my wife's a venture capitalist, and I have many friends who are in venture capital. They always say the first, it's the kiss of death. If they go into a pitch and they see that the founders are still working, they won't even consider it, because they understand that the IP issues are not clean and that you're not truly dedicated to this startup that you're trying to create. So that's the first area for the founders. Also, for consultants and employees that you bring in, oftentimes you face the same issues, right? So for your employees, you want to make sure they have a similarly clean break, that they're not working for another company. With consultants, you want to sign them up to formal consulting agreements. So employees, you want to sign them up to formal employment agreements. Consultants, you want to have them under formal consulting agreements. Sometimes with consultants, it's a little mixed, because they often bring things to the table. And it often seems like, well, gee, do we really need to go to the trouble of a consulting agreement? But what makes it really important is you want to surface those issues up front. If they're bringing things to the table, you don't want 2 years from now for them to say, well, I really just let you use some of this IP that I created separately, and therefore I own it. You might have some limited right to use it, but you're not the owner of this intellectual property. So it's a way to surface any of these IP problems up front rather than waiting till later. The second way that I see companies get in trouble is, you've got a product under development, maybe you've even got some alpha or some beta versions of it that's ready to go, and oftentimes you want to work with one or two key customers. Or maybe down the road you want to do a partnership with a company like Cisco, because you have complementary products. And what often big companies will want to do is they'll say, look, if I'm going to work with you, I need to have some control of the IP. I don't want to spend all this time working with you and then have you take all the fruits of my investment in my ideas and work with one of my competitors. So oftentimes you get a form agreement that will either give them ownership or broad rights to anything that's come up in your collaboration with them. And that's the second way that companies get into trouble, and you have to really be very focused on what are the aspects of my product, my IP, that's really important to me and that I have to control. Because someday, whether I become a significant generator of revenue or I want to be acquired, that's going to be the first thing an acquirer will look at. What IP am I actually buying?
I think the other danger there is if you haven't assigned all IP properly to the company, or you've had some people who have contributed to the company while they were actually under an agreement with another company, if you make it and you're having a lot of success, and that other company recognizes that, so-and-so employee was moonlighting for you as a consultant, for example, or you really started your project while you were employed at my company, once you start seeing that success, they will sue you and say they own your IP. And obviously that's
we've heard of
every
the
startup.
Winklevoss twins?
Pardon?
We've heard of the Winklevoss twins?
Yeah.
Every startup's worst nightmare.
Yes.
That's why it's so important.
Yes.
Sherman, assuming that, now that what I heard was, you as founders are starting off, you want to make sure that the IP that the founders are developing is clean, and the IP that they've contributed to the company is clean. When you're working with consultants, making sure that they have assigned all of the IP rights to the company, so that down the road they don't come back and claim it. If you're hiring employees, you want to make sure that they are signing invention assignment agreements, so that whatever they're developing as part of their employment with your company, is all assigned to the company, and the company owns all rights to that IP. Now, once you've started you started doing some serious product development. You're developing software. You're starting to develop business models. How do you start thinking about filing for patents or filing for trademarks, copyrights, all of the rights that the government gives you, to protect under law? How do you think about that? As you're in an early stage company, you're constrained for resources. What goes into that decision process?
Yeah. I mean, I think first of all, it really depends on the space that you're in and the business model that you have. So, things like patents are, I think, a great idea in theory, but you really have to think about how will it add to the value of my company, right? So typically, like for things like patents, you get it for two reasons. One is it's an asset of the company, right? And sometimes it can be helpful in terms of your valuation. It can be useful when you're pitching for VC money, if you get acquired. So that's great if you have patents that are going to be truly valuable. Obviously, I think a lot of times patents tend to be fairly small and incremental. If you're not going to do that, then realistically, I think for a lot of companies, the patents are of limited benefit unless you're going to sue to enforce it, right? So if you're a big company like an IBM or a Cisco, then it's useful because you have a portfolio. You can use it to defend yourself against other people that want to collect patent royalties from you. But for a startup, my counseling is you really have to think strategically. There's a cost to filing for patents. There's a resource issue, right? You're taking your engineers and having them work on patent applications. So I always counsel people to be realistic about what they're looking to accomplish when they think about filing patents. Obviously, trademarks, domain names, those are the things which you want to, you typically want to do your filings relatively early if it's going to be, for example, your corporate name, and you want to establish your domain name. So those are the kind of things that you want to do early on in the cycle, rather than patents typically.
Anything to add, Mel?
No, I agree entirely.
We just talked about protecting the company's IP, making sure that your IP is clean. Any questions on that topic? There was a question at the back there.
One point over there, I think Stanford University has a model, the VCs follow that if you're from Stanford, we need a clearance letter from Stanford that you are clean to pursue whatever you do. Otherwise, you have to enter into a royalty arrangement or a IP purchase arrangement from Stanford. I think these two guys, Google, they pay huge amounts of royalty. I mean, Google pays a lot of royalty to Stanford on that basis.
Yes, that as Manishi said, if some of the IP that you've been developing has been part of the work that you've been doing as a PhD student or a professor or anything else that you're doing with the university, you want to make sure that you have the right licenses and the rights are spelled out in some of those agreements.
And I would add to that, patents have become huge moneymakers for universities. And depending on the university, some have gotten very, very aggressive about trying to monetize ideas that have come out of their faculty. So you definitely want to be careful.
So my question was about the first segment comment about IP, assigning even code that one has written. How do you actually go about doing things like piece of paper that you might have talked about, written, or some pieces of code that you wrote, maybe threw it into GitHub somewhere? How do you assign those?
So when you're, if you're founding the company, if you're doing an initial, the initial issuance of founder stock, we usually do sort of a blanket assignment. So, everything that you have created that has to do with, the business of the company would be assigned. You don't want to leave anything out. You don't want to create a schedule of everything. If there's something very key, perhaps you would attach it or mention it explicitly. But usually it's, we would do it as a blanket assignment of anything related to the company at all.
So there's usually two halves to the issue, right? The first is making sure that nobody else has a claim on that IP, whether it's ideas or it's code. So that's the first half. And whether you're a founder or you're hiring somebody, more typically, if you're hiring a consultant or employee, you want to have some reasonable basis for being sure. The most obvious one is if they're still working for someone else, then you know you have a problem, right? Some companies go to the point of saying that they speak to all new employees and inform them that they're not to bring any IP from the previous employer, whether it's an idea that is clearly from the previous employer or code. You'd be surprised. Some employees have the perspective, well, if I write the code, it's mine. I should be able to take it with me somewhere else. And unfortunately, that's not true. The second piece, which is now that we've established that it's not owned by somebody else, you want the proper agreements and legal language in place that assigns that IP over to you, right? So ideas typically fall within the scope of patents or trade secrets, right? And then, copyrighted stuff, you have language that says that if you write code, for example, anything that's subject to copyrights, such as code, is what's called work for hire, meaning you created it for me, therefore I automatically own it at the moment of creation. So you just need to make sure you have the right agreements and language in place, and these are all pretty boilerplate.
If one of the co-founders is from academia, a professor, would you sort of recommend that person going on a sabbatical? How does the IP work in that case so that the university or the school doesn't really have any association with the IP that's created?
So I guess it really depends on the university. And I don't have that level of detail, but I think I think it is not uncommon to seek to get a letter from the university saying that they have no claim on the IP. I mean, where it gets a little bit tricky, obviously, is if they take a sabbatical and it's an idea that they had sort of conceived, maybe even worked on a little bit while they were still on the faculty, and then they bring it in, and they use that when they're on sabbatical. Then it gets a little tricky, which is why you want something clean from the university.
And I would say, at least in my practice, it seems universities like Stanford that have benefited so much from their graduates going and creating companies that are successful. Stanford, in my experience, is pretty open to putting in place agreements that work for their graduates or the professors or whoever's involved. Whereas other companies who aren't so enmeshed in the startup community might have less favorable policies from the individual entrepreneur's perspective.
Okay, while the mic is traveling to that side, can I ask you a question? This thing about this non-poaching rule that they have. Google and Apple and all these guys got together and decided they won't poach from each other. I guess it's partly an IP issue. I mean, they take away a whole team that carries certain IP, and they agreed not to do such a thing. And the government is against that. They've been suing these companies that you can't have a non-poaching agreement.
It's partly IP, but the bigger issue there in that there was a class action lawsuit, and the bigger issue there was around employment law and an employee's ability to get as much reward that he or she can get for his or her talents. I mean, and placing restrictions around that. It was if a company has valid IP concerns. So if you have an employee there's a larger company who's working on a particular product, and the company and Cisco often saw that with companies like Juniper, and there are other ways of protecting that. But Manishi, the arrangements that you are referring to were largely around employment law and preventing, having any kind of restrictions around employees to do what they want to do.
Yeah, I think the IP concerns can be addressed, right, in a way that doesn't really touch on the poaching issue. It really was more an employment and antitrust issue.
So my question actually is a little bit orthogonal, but comes from the pain that I've experienced. Is that are there any resources for finding the correct IP lawyer? Because a lot of quality of these IP depends on, to some extent, obviously your idea, but also depends on the lawyer, and your life can become easier if you find the right kind of lawyer. Can you recommend any resources that I can sort of look up to? it's extremely difficult, at least from where I stand, to find a good IP lawyer actually.
Well, you have one here. But Shravan, do you want to speak to that?
Yeah, I mean, isn't that always the problem with professional services,
True,
right?
I agree,
right.
but-
You know, if I could find a good barber, I'd use him. Or maybe that's me rather than the barber. Yeah, you know, I think a lot of it really is word of mouth. You know, I always think that professional services that, you know, you ask around your network of friends and see who's had a good experience with one. I think, you know, the best lawyers tend to be the ones that are practical, right? Because anyone coming out of law school knows the laws and the regulations. Obviously, you get more experience as you go along. I think the quality that I always find the most useful in a lawyer is somebody who understands the business, understands what's important to a startup, and, you know, what's more theoretical.
Yeah, it gets important when it comes to choosing a patent lawyer specifically. You know, since patent law tends to be very specific around, you know, knowledge of prior art and knowledge of that particular area of technology gets to be important. So it's important when you're seeking out a patent lawyer. It's more important to seek out a patent lawyer who understands your technology.
Yeah, very true.
I have a question. Say you are currently working for an employer and you got a great idea. So you start your company and then you quit your job and start your company and then with that idea. But you actually got the idea while working for somebody. So can your employer still hold you hostage and come after you for that? Or is it like, how does it work?
So there's in California, there's a law that protects you as the individual so long as you have any work to, you know, if it's just an idea in your head, I think you're fine. If you're doing any work on the idea, if you're beginning to sketch out business plans, starting to write code, starting to, you know, figure out what this company is going to be, you want to make sure you're doing it on your own time, on your own equipment, and that it's not substantially related to your day job. Okay? And then there's a, you know, and then you're clean. If you're using your work phone, if you're working during your business hours, if it's what you're doing at your day job, then the protection's not available.
So my question is regarding licensing an IP out of a university. An IP goes through different stages of professional, non-professional PCT applications. When is the best time to actually license it out in this entire life cycle of an IP?
You mean license it as a product or as pure IP?
Just as a pure IP.
It's pure IP. Well, you don't actually get actual protection until the patent issues, right? And so all of those preliminary stages are to the point of issuance, right? So, you know, but as a technology, you can still license out know-how and trade secrets, right? So I would say, you know, if you can find somebody that is interested and wants to license your know-how and down the road, when it becomes an issued patent, to have that as part of it, then there's no particular time that I would say is necessarily better or worse, right? Just finding somebody who finds value in what you have.
Yeah, because I mean, from an early company's perspective, I mean, licensing an IP out of a university is also expensive, right? So you're unnecessarily taking like a lot of burden on you when the patent is not even that valuable, or it's not even issued, for example.
Right.
It's still in the professional or non-professional stage.
Yep. Yeah, so it just becomes a question of, you know, will somebody find value in the IP that you have?
And usually our derivatives.
Just one question. Let's move on to the next question.
No, this was not a question, but more addressing the university issue. What I have seen more with patents literally across the world, whether it's US universities or foreign universities, typically if the main founder is a university professor, then the way the patents are structured is that the university owns it and has an exclusive license to the startup. So, and typically the prosecution is also controlled by the university, but they allow the licensee, which is the startup, startup to go with, whatever kinds of amendments they want to the claims and everything else. But otherwise, the rights are held by the university. So it's not that the university clears the startup and grants rights to the startup, whether it's the UCs, other state universities, private universities, all of them.
That's exactly right. I mean, it's it depends on whether the university is ready to assign all the rights. Most likely not, but what kind of a license are you going to get? And there are all kinds of, whether you're getting an exclusive right, and therein depends the value. How much are you going to pay? Are you getting an exclusive right? Are you getting a non-exclusive right? What are the limitations? What's the field of use? So there are a number of issues that you need to think through in that license agreement.
Yeah, so I mean, I think in the ideal case, you'd get something from the university that says that we don't have any claims on this particular invention. Maybe it was not done under university auspices, right? So that'd be the ideal. If you don't get that, then obviously what you want is a free right to use. And then that's where it gets a little bit tricky, right? Because the universities that tend to be more aggressive are the ones that want more money. That's what it really boils down to. So I think that universities are usually not against commercialization, right? Because they're not in a position to commercialize it themselves. What they want is money.
Yeah, so startup typically has many advisors and professionals who are working in other companies, and the problem, because let's say they contribute to an idea, then how do we deal with that? Because by definition they are advisors and consultants, so they won't be full-time employees in your company. But you want their input, so they will be giving some ideas and they will be patentable. So how do we deal with that?
Can you talk about consultants and advisors?
Yeah. So first off, when you file for a patent, you have to list all the inventors. You have to name them in the patent application, and it's an important thing to do. You want to be sure that you capture everyone, because the failure to name an inventor is a reason to invalidate a patent, right? So you do need to be careful about that. So the right way to do it is you want everyone signed up to a consulting agreement, right? It doesn't have to be maybe by name a consulting agreement, but an agreement that clearly sets out that they are assigning ownership of of any ideas to you. So typically the way these things are written is that there'll be the blanket, you consultant are assigning ownership of all IP to me, and you're not bringing any pre-existing IP to the table. And there'll usually be an exhibit or a schedule where they are allowed to say, except I'm going to carve out these things that I'm telling you up front are pre-existing or that I'm not contributing in.
Actually, I was more concerned about their employers coming after us saying that this is our IP and we consult.
Yeah. So I mean, again, I think we get back to the issue of if you have people that are working on your stuff while they're employed by someone else, you have a problem.
Can you talk about patent trolls, legal firms that come after startups?
Yeah, they're bad.
Are they a thing of the past?
I don't know what else to say.
Are they a thing of the past, or has Congress done anything to prevent patent trolling?
Yeah. So generally speaking, the answer is yes, right? So so Congress has not done much, and the problem is that there's a bit of a tension between the IT industry and the pharma industry. And the two industries are different in the sense that pharma has these very long product life cycles, and they make these huge upfront investments, taking things all the way to clinical trial. And so I think with some justification, their argument is that if you make patents harder to get, easier to invalidate, you're really going to hurt pharma, which depends on a huge upfront investment. So that's been held up in Congress for quite some time. And Cisco, the guy that Raj and I used to work for, had invested quite a bit of time in trying to lobby Congress to change things. But where the real change has come from has been the courts, particularly the Supreme Court. The Supreme Court has stepped in, and I think they see that the current patent system has become an obstacle to innovation. You get all these, I think Intel once did a study that said that there are 35,000 patents that read on their microprocessor. So if they had to go out and literally get a patent license for every single one of those 35,000 patents, they'd never be able to release a product, right? So the courts has made it easier, number one, to challenge the validity of a patent, And number two, by raising the standards. There's something called obviousness. If your patent is so obvious compared to what's already out there, the courts have said we need to raise that threshold before a patent is valid.
Raj, you want to go on to the next
Yeah,
section?
let's move on. Thanks, Manish. We'll move on to the next topic. So we've talked about companies formed. You have you're starting to develop. You've protected your IP. You're starting to develop. Products or services. Now you're looking for money. You go to a VC. You go to friends and family. You go to other types of investors. You might go to a corporate for getting funding. Laura, how do you think about structuring your financing round? What are the most common options that are available to you?
Yeah, so it depends on where you are in your development stage and what funding opportunities appear to be available. So if you're having great success, you've formed a great team, your development is coming along at a wonderful pace, you very well may be able to trot down Sand Hill Road and get a venture capital term sheet for a Series A financing at a great valuation, and raising enough money that'll get you to your next milestone. That's the ideal world. A Series A financing is usually at least around $5 million, and you want to make sure that you're raising enough money to get you to your Series B. And your next financing should be, like I said, at the company's next obvious milestone. So it's hard to raise money, right? It's hard to get investors to agree that they're going to put money towards your team and your product. So it's important to, when you raise enough to be able to build out your team and your product, and if there'll be sales in that cycle, to get yourself in a position that will enable you to pitch again successfully. So if you think that you can achieve your a big milestone that'll set you up for your next financing round by you're going to need $10 million in order to get there, then if you go raise 8, you're probably going to find yourself running out of money before you've got a great pitch for your next round. So that's sort of the the upside scenario. If you've got something, things are going really, really well, you're able to get venture capital financing pretty early. Alternatively, a lot of early stage companies start out with what we call a seed financing, and that can take several different forms. You could do seed preferred stock, which is a lot like a Series A round. I understand you guys have already had presentations on VC financings generally. So a Series Seed round is also a preferred stock round, just like a Series A, except it's usually a smaller valuation, a smaller raise, and oftentimes the documentation will be simpler in order to keep costs down for everyone. I typically see Series Seed used for raises of $2 to $5 million. If you're looking at raising less than that, say you just have a couple of people and you're just trying to get things off the ground, you can look to angels, you can look to friends and family, maybe a smaller investment organization. And there are two alternatives that we see commonly for rounds that are less than $2 million. Those are convertible notes, so convertible promissory notes, which is actually a debt instrument, so it's a loan, and generally in the market, the understanding is in most cases these loans aren't being paid back. The idea is they're going to convert into equity when you have your next equity financing. So there is a repayment obligation under the notes. It is a promissory note, and if it has reached its maturity date, depending on the terms that you've agreed with your investors, they could say, hey, pay me back with interest. You can write the terms of the note to say, okay, well, if it reaches maturity, we're going to convert you into Series Seed stock instead. These are all, points of negotiation. the benefit of doing a convertible note is you don't have to set your valuation up front, and the documentation is much simpler and cheaper. So you do have this, debt obligation that has to be repaid if, in theory, if it matures, but you don't have to, at that very early stage, agree, well, the company is, worth $10 million. However, the investors typically are looking for either a valuation cap, so they're getting some assurance as to what the valuation of the company is, or they'll ask for a discount. So they're saying, hey, we're putting our money in early. We're taking risk by funding you, before you're at that milestone where, Sand Hill Road is willing to put money in. So we want to be, when our notes convert into that Series A stock or Series C stock, we want a 20% discount, for example, on whatever price is agreed in that round. And that's very common. The alternative structure that we're seeing more and more of lately are called safes, which is something that Y Combinator came up with, a simple agreement for future equity. They're very similar, but they purport to not be debt instruments. I think the jury's still out, whether the IRS would, potentially treat them as debt. But they typically don't have a maturity date. They don't need to be repaid. They don't accrue interest, things like that. So it's a simpler agreement in some ways. But I would say they're still less common. They are gaining traction, and some people prefer to use safes. I think, in my experience, because they sort of feel less weighty. If you're issuing a convertible note, it is debt, and there's some weight to that. We tend to find that people issue safes more readily than convertible notes, and in some cases, when it comes time to convert all of them, we see founders sometimes feeling like, oh gosh, that created more dilution than I had anticipated. Because it feels easier to issue them. It's the same as a convertible note for all intents and purposes. Dilution is the same, but I think people tend to treat them as easier to issue, and the dilution is real, and it needs to be accounted for as you're planning.
At some point, you got to pay the piper. Is what you're saying. Are there any downsides to issuing safes in convertible notes? One is, you got to think about the dilution. Any other downsides that you can think of?
Like I was saying with notes, they are debt instruments, and unless you've contracted otherwise, they do have to be repaid at maturity. You are issuing equity in your company. And whatever valuation or discount, et cetera, that you set, does become part of your next round. So when you're selling your preferred stock, all of those issuances are going to dilute you and your founding team. But yeah, no, these are common ways to raise money for the company. I would say there are a lot more benefits than downsides to using either of them. They're both simpler and cheaper than doing a preferred stock equity round. So if you're trying to raise, $1,500,000, up to $2 million, they're great options.
I want to move on to. I know there was a whole session on structuring finance.
Yeah, if you refer to workshop number 2, the video is up there. So workshop number 2, I think, covered this over 3 hours. So you have a lot of details over there.
So we won't get into a whole lot of detail on that. Now I want to move on to customer agreements and vendor agreements. You have. You have developed an alpha or a beta version of your product. You are lucky enough to find a customer. You are, they send you in most cases, if you're trying to sell to a large company, like a Cisco or Google, Facebook, they'll give you their standard agreement. You usually don't have a whole lot of leverage around, you can't turn around and tell them, look, I want to use my own agreement. That's rare. Sherman, you're faced with, say you're selling something to a bank. You're a small company. You've developed some piece of software, some service. What are the kinds of things that you would look for, and really, knowing that you don't have a whole lot of leverage, what are the kinds of things that you should be looking for in those agreements and really be careful about?
Yeah. So typically, I think the biggest issues are, liability, right? Because especially when you're dealing with a big customer, they typically have standards as far as what they expect the vendors to stand behind, and part of standing behind it is taking on financial liability in case the product doesn't work. The second thing, and this is operational, is usually with a big customer, they're conditioned to expect a certain level of support, right? And I always find that with my startup clients, that can often be the challenge, because you haven't really developed to the point yet where you've got, you're able to provide the support to the extent that some of the big customers will expect. 7/24, 365 days a year, certain response times. Oftentimes big companies will build in financial penalties if you fail to respond within a certain period of time. So I typically find those are two of the more negotiated things. With startups, I'm realistic that your biggest risk is that you won't execute to the point where you have enough customers to stay in business. It's not some obscure, indemnification clause, right? That's not what I would typically focus on. But those tend to be the two bigger things. The other piece of it is, depending on the nature of the relationship, we sort of touched on intellectual property, and I often find that when you're a startup, and particularly for your first few customers, the relationship tends to be, I've got this big customer, they want to work with us because they really like our concepts, and maybe they've seen our alpha demo, and it's going to be a win-win because they are going to give us feedback, they're going to pay us a certain amount of revenue, and what they're going to want out of this is a product that sort of meets their needs. Well, the rub is oftentimes in the meets their needs, because oftentimes a big company will take the point of view that, well, we're telling you our needs because that's valuable intellectual property, and also we don't want our needs translated into a product that you sell to our competitors. So if you're in a situation oftentimes with a startup and you've got an early big customer, I've often seen startups get in trouble because they say, well, we'll be willing to give on the intellectual property terms, but the price, of course, is down the road. They have difficulty selling to others.
Great point. And separately, you have in today's SaaS-based services, or sort of the more interconnected products. Even as a startup, you'll be working with vendors. You'll be working with partners whether for marketing or sales purposes. In some cases, if you're licensing Oracle, for example, you don't have a whole lot that you're going to negotiate in an Oracle agreement. But if you're licensing in technology, or you're partnering with a vendor, or somebody who's a sales channel partner, what are the kinds of things that you would look for?
Yeah, so some of the key things, we've talked about IP enough. I don't think I need to touch on that. But oftentimes, if you're working with a partner, oftentimes the thinking will be, I've got A, you've got B, they're complementary, and they would work great if sold together. Oftentimes, one big thing is who ultimately controls the customer. Who sees the customer? Who picks up the phone when there's a problem? And it sort of cuts both ways, right? Oftentimes, for your company, you want to be the face in front of the customer, right? Because in the long run, you want to develop a relationship with the customer. Obviously, the flip side of that is then the customer will expect that you'll be the party that they call if there's a problem. And particularly when you're working with a partner or a vendor product, then you'll be responsible for how your product integrates with that other company's product. And sometimes if the customer perceives you as being their vendor, then you may need to take calls for your partner's products. So that's a big thing that you need to sort out, right? Who touches the customer? How do you handle joint sales calls? Who is responsible for support obligations? You can usually work something out that makes sense. Maybe you take levels, if you want to control the customer, you do level 0 support. You take in the call and you take it to the point where you figure out, well, the problem really is with my partner's product. And then you can switch it over to them. But those are some of the key issues when you're dealing with inbound technology or working with a complementary partner.
Any questions on those topics? Common customer agreements, common vendor agreements, commercial transactions of that nature.
Would you like to touch upon the escrow that one has to do because you're a small company? You put your code in escrow.
The software code escrow, the source code escrow.
Yeah.
The dreaded source code escrow.
I know.
No, you're not recorded.
If you're not recorded, you don't exist.
Yeah, you are basically you are a small company, and then you go and approach a large company, and they want to make sure that you are not a fly-by-night company, right? And that you just do not vanish overnight with all the code that you have, and then suddenly this company is stranded. So they obviously ask you for an escrowing your source code, and so little bit to educate these people on how that process works.
Yeah. So, I mean, there are two aspects that are really key to that, right? The first is, are you willing to put your code in escrow, right? And, depending on the company, frankly, for startups, I don't really care that much, right? Because until you are generating a lot of revenue off of your code, how much value does it really hold, right? The second, which is really related in part to the first, is what's the condition that will get triggered and what happens once it gets triggered, right? Where I think I would be less sensitive rather, would be things like bankruptcy, right? Because if I'm bankrupt, then it's only my creditors that care about whether or not the source code goes out. I'm wiped out as an equity holder anyhow. Where companies get a little more aggressive and the negotiations get a little more contentious is, if there are situations short of bankruptcy, right? Sometimes companies, your customer will say, if I feel insecure about your financial status, or if I feel that you're not satisfactorily providing me with support, I have the right to trigger escrow and get the code and use it myself. Frankly, my experience is, having worked for a company that it was part of their standard terms, number one, the number of situations where escrow actually gets triggered is vanishingly small. Number two, from working with technical and business folks, even where they have the right to trigger escrow, nobody wants to touch the code. I mean, the way they put it is, I'm going to get hundreds of thousands of lines of code. What do you expect me to do with it? Am I really going to be able to figure out and support it, maintain it, fix bugs? So it's a little bit of a non-issue. That said, I would be okay with escrow, trigger of being bankruptcy. Other things I would push back on.
I think there's a situation where a customer may prevent you from in any way dealing with a competitor of theirs. In other words, suppose you sell your code. I mean, let's say you're working with Oracle and suddenly you sell your code to SAP. I don't think they're going to be happy about that. They won't even allow it.
So this is a situation where I'm a small company. I'm licensing my product to Oracle, and then I turn around and I sell my whole company to SAP.
SAP.
Yeah. So I mean, that's maybe somewhat related, but it's really an assignment right? And sometimes companies like an Oracle will take the point of view that I'm buying from you because I know who I'm dealing with. If you go and are suddenly you're owned by a competitor, I know I'm going to get the dumbest technical support people, every time there's a bug in my product. So it's a not irrational thing. Typically that crops up in a different part of these agreements. That's the assignment right. And for a startup, it's a pretty tricky issue because startups often, their exit strategy is to be acquired, right? So typically I push back pretty hard on those types of things where there are really two flavors where that gets affected. One is, do I have a right to be bought by a competitor of yours, right? And I think if it's worded as it's a limited set of competitors and it's named, then I have visibility into what I can or can't do. The second thing is, if somebody's looking to acquire me, what is the processes that I have to jump through? Am I going to give a right of first negotiation where SAP wants to buy me, but then there's a clause in it that says, in that scenario, I have to go talk to Oracle first, and I'm not allowed to accept any offer from SAP for 30 days. The mechanics can get tricky, and it can actually discourage potential acquirers.
So I have a question about partnerships that you mentioned. So typically, many times when you are dealing with wanting to sell to a larger company, you as a startup are much smaller entity. And at least in our case, we are finding it that we want to bring in another intermediate company which is much bigger than us. But in such cases, my fear is that at some point that this intermediary bigger company might just take over into this deal. How do I protect myself or my company? Should I precipitate a licensing deal with this intermediate company, or what are my options in this case?
Yeah, yeah, and it's not a common issue because if you are not, if you don't have the customer relationship, then the intermediary company could at some point say, well, you, the startup, I can just swap out your technology and swap something else back in. And maybe it's because it's too expensive to use you, I want better terms or whatever. So it's a very real concern. So I would say there's really two things. One is sort of a business evaluation, right? How readily could they switch you out, right? In some cases, if there's not much of a deep integration, if you're communicating, let's say if you're a software company and the communication is via APIs and it's relatively easy to swap somebody in, then the concern is more. If there's a deeper level of integration and the cost of switching is more difficult, then you probably have a little bit less of a concern, right? So that's number one. Number two, it's a tough issue, right? Where you have the right leverage. Let's say your technology is unique and it's difficult for them to get it from somebody else. What I would try to do is I would try to tie them into some type of exclusive supply relationship, right? And there's various rationales to point to, right? Number one, maybe I'm investing resources, right? You can't expect me to invest resources to integrate with your product if I don't know, if I don't have any assurances that down the road you're just not going to swap me out. Number two, there could be IP issues, right? I'm going to be just in the process of integrating with you and working with you and servicing the customer. You're going to gain access to IP, and I don't want you to be able to turn around and use that with someone else. So that's typically a case where the intermediary is going to bundle your product. Obviously, if it's more of a OEM white label type of arrangements, there's a different set of concerns, and we can talk about that if that's an issue.
Actually, there's another issue, and I've seen 2 IIT cases that face this. Mm-hmm. If your intermediary customer is your distributor, and they control 80% of your distribution, example, your revenue, they suddenly make an offer to buy you out. And if you don't sell to them, 80% of your revenue is going to vanish. You don't have a choice. I know Nielsen did it to one of our IIT Madras guys. I know there's that Japanese financing company did it to an IIT Kharagpur guy. They said, we are going to buy you for this price. The fellow said, no, but I'm worth more. I said, no, you're worth this much. Mm-hmm. You don't have a choice.
And that's a generic business problem, right? Because you want a diversified customer base, you want a diversified channel base, you don't want a dependency.
Sherman, I wonder whether open source is something that would be of interest to this group. Something that, as it's seeing startups in the investment context, it's the sort of thing that very frequently comes up in diligence. Investors, venture capitalists want you to give representations, that there's no copyleft effect, et cetera, et cetera. I wonder if you might speak to that a little bit. Sorry to jump out of my the 5-minute version.
I think Raj knows some of my pain when it comes to those issues, right? No, it's a very real problem. I think one of the senior engineering leaders at a company I used to work for, the way he put it to me once is that if I give a code development project to 10 engineers, 9 of them are going to go back to the desk and start looking for open source right away, right? It's a shortcut, right? It's out there. I think the biggest challenge is being able to find the biggest challenge is being able to have the right internal processes in place and have your people aware of the problems that this can cause, right? Because engineers, I was an electrical engineer myself. Engineers tend to like to reuse things rather than develop things from scratch if they don't have to, right? So, so there are a couple. Well, the biggest thing is that when you're a small startup and you're under the radar, it seems like a cost-free way of getting to market faster, right? The problem is that when you get acquired, companies have learned that the open source community does come after you if you have their code in your project. Particularly the more visible open source projects have a tendency to have people in the community that will come and in some cases actually sue to enforce these things. So acquirers have learned oftentimes to make diligence on open source part of their due diligence. And there are also some tools out there. The tools are not great, but there are some tools out there that some acquirers use to scan for open source in your code. So it's definitely something that you want to be mindful of, right? Is it a startup's top 3 concerns? Probably not, right? But you do want to be mindful of it and at least have some degree of hygiene for your engineers.
Yeah, and as Laura said, often when this comes up is especially for an early stage company, at some point you're going for financing, or if there are representations. The investor will want to make sure that you have representation. Give me a list of all the open source that you have in your product, and it's important to have that discipline early on in your development process to have a proper listing and repository of all of the open source software that you have in your product, all of the licenses that each of those pieces of code are subject to. It's just good hygiene, and it's good practice, because you don't want that issue to become a sore point or something that an investor would get concerned about when they're doing their diligence.
I should mention this is less of an issue for SaaS-based companies. Still, if you get acquired, the acquirer will probably want to know. But if you're doing a SaaS model, copyleft is not as much of a problem.
Hi, thank you for taking my question here. We talked about a lot of topics here. You talked about a lot of topics, incorporating a company, IP protection, customer contracts, and all that. I guess every company faces all those issues at some point in time. So before you start off, do you try to establish a relationship with each and every attorney that is expert in certain area? Are there any areas which are very critical that you want to have a relationship with an attorney before starting a company, rather than running into a contract, running into an issue, and then trying to chase some attorney? Is there any right strategy there?
It's a great question, Laura. You want to talk about what startups should be doing when thinking about how do startups work with attorneys, but with law firms?
Sure. So I would say, as a startup practitioner, we basically serve as kind of general outside counsel to a lot of small companies. So even though I'm a corporate attorney by training, for better or for worse, I dabble in IP. It's like a lot of early stage startups face a lot of the same issues. So someone who's specializing in startup work will be able to address a wide variety of those issues. And when more specialized questions come up, probably have relationships, whether it's in a large firm like Fenwick or DLA. We certainly have colleagues that specialize in those, tax questions or the IP questions that are beyond, what I see, so many startups facing in my day-to-day practice. If you're working with a smaller organization, hopefully they have the right relationships to go to outside of their firm for those specialized questions. As far as sort of potential pitfalls go for early stage companies, I would say that the stock issuance issues are pretty darn important, and you want to make sure that you're doing things right from a stock issuance perspective and a tax perspective. Granting equity, whether it's stock or particularly options, if you're trying to grant equity to your employees, the tax rules are extraordinarily complicated, and it's if you're not working with an expert in the field, you're very likely to get things wrong. It'll cause negative tax implications down the road. People think they have rights that weren't properly perfected, and if an option wasn't properly issued, then there's oftentimes no good way to clean those things up after the fact. For example, say you promise a service provider a stock option, you've only been around for a year, the fair market value at the time that they started was 5 cents, 10 cents, something like that. If you don't get the option properly approved by your board of directors and issued, then that person thinks they have that right to purchase those shares at that price, and several years down the road, when hopefully your valuation is much, much higher, if it turns out, oh, this wasn't actually issued properly, it wasn't approved properly, then your fair market value is now 80 cents, and this person thinks they have a right to a 10-cent option, and there's very little you can do to get them the equity at the promised price. So that's one area that I think is particularly important to make sure you're working with someone who really knows what they're doing. And the other issues, I think, are the IP assignment issues that we touched on a lot at the beginning. Making sure that the company owns its IP, that there aren't third parties out there that have rights to the IP. I think those are the really critical issues. And if you're working with somebody who works with startups, day in and day out, facing these issues, they'll be able to answer a lot of those questions and refer you to specialists as needed.
I think the question that must be buzzing through everybody's mind is, attorneys are so expensive. How can I, a starving startup, use an attorney, pro bono or pay later or through stocks, which may or may not materialize to anything, So do the attorneys have some sort of a formula for dealing with startups who are starving at the moment, but hopefully few of them will make it to big time someday?
Yeah, I mean, I can't speak to DLA, of course, but certainly at Fenwick, there are, sometimes discounts are available, sometimes deferrals are available. Certainly when it comes to, just the basic services around incorporation, sometimes flat fees are available. When it comes to, like a law firm business model, to be honest, we're not making money off of incorporations. If anything, we're likely to say, okay, yeah, we'll do it for $5,000. And that's just to get those promising companies in the door. And we recognize that as you succeed, we succeed. And when you're, if you have a big acquisition, then we'll make appropriate fees at that time. But that very early work when, you hardly have any money, we're just trying to, cover our costs, if that. We're not, trying to make a profit at that stage. And by working with, many, many startups, yes, some won't have those long-term relationships that end up being profitable for the firm, but some will. So it's a little bit like the VC model of, you work with a lot of companies, and hopefully many of them will mature and be profitable down the road. But at the very early stage, it just doesn't make sense from a law firm business model perspective to try to make profits at that stage. So I think you'll find that a lot of firms that practice in that area are willing to give discounts, deferrals, flat fees, things like that for the very early stage work.
Yeah, I think from a startup's perspective, the two key things, one is the expense, and there's no doubt, right? Law firms are an expensive model because we have so many specialists running around. The second is really predictability, right? And that's as much of an issue, I think. You just don't want to be surprised. So typically what a law firm will do, as Laura said, is flat fee models, sometimes will defer. From a law firm's perspective, you're almost making an investment in startups when you work with them, because you kind of have to evaluate. You're not going to make money in the beginning. You'll probably lose money in the beginning. And so it's a little bit of a investment, and you have to evaluate what the likelihood is. But for the right company, fixed fee, deferred, those are arrangements we would consider.
I think the other thing worth noting is there's a lot to be said for following what's become standard in the industry. So going with a Delaware C corporation, going with choosing terms that are comparable to the National Venture Capital model documents, things like that. The more you're able to keep your terms standard and plain vanilla and like what all the other startups in Silicon Valley have, the cheaper you're able to keep your costs. As soon as you say, oh, I want to do an LLC, or oh, I want to have this really unusual relationship with this third party, and we're gonna, as soon as you start adding bells and whistles, that's when the costs go up. There's a lot of efficiency. We can do things quite efficiently if you're sticking to the very standard things. But as soon as you begin customizing, this costs go up a lot.
To cut the costs, what would you say if these guys in the beginning they use the standard drop-down forms? There are a lot of drop-down templates available on the web, and they use some of them till it gets too tricky for them to handle, and then they come to you.
I would address that, Manish, as a general counsel and as a consumer of outside legal services. All I can say is you get what you pay for, right? Sure, there are all these different templates and forms available, and so long as you're doing something plain vanilla, it's great. But I would say, especially for important issues like the equity issues that Lara talked about, or some of the early IP assignment issues, if you're doing something non-standard, or you want to make sure that maybe you can do some of the legwork by doing your term sheet yourself. But for some of these critical issues, you want to go to a law firm or a lawyer who knows what they're doing, rather than get stuck later.
I will also say that I have never seen a company come in that was formed on LegalZoom or one of those that I haven't had to clean up. So it's typically cheaper to do it right the first time. Cleanup is often more expensive, and as I was mentioning, sometimes there are issues where you can't clean them up. Missed 83B filing, you can't clean it up most cases. So I think I certainly advocate for biting the bullet and paying somebody who knows what they're doing, within reason, to get it right the first time. It's
especially the critical issues. Yeah,
absolutely.
I mean, would I go out and spend hundreds of thousands of dollars on patent filings if I'm an early stage company? Maybe, as Sherman said, maybe not. But some of these critical issues, I do want to think about it.
So one of the questions is, as your startup trying to attract the employees can become very demanding. And to your point, they can ask for anti-dilution clause, or the other thing they can ask for is a single trigger. Can you address these two things, and what are the implications?
Sure. I would say both are extremely unusual in the context of Silicon Valley venture-backed startup companies. Anti-dilution is something that often is granted to preferred investors in connection with preferred stock financings, where they're giving you a big check and they want assurance that you're not going to sell shares at a lower price to somebody else next week. But for employees, I would say it's practically unheard of. And as far as acceleration goes, I think acceleration is pretty common for founders, the founding team, to have, usually it's going to be double trigger rather than single trigger. So if you're not familiar with the lingo, this means if the company is acquired, a single trigger acceleration would mean, say you're only halfway through your vesting schedule on your shares when the company is acquired. A single trigger means the acquisition triggers the rest of your shares to vest, or maybe it's a percentage, maybe it's 50%. Double trigger means if there's an acquisition and you are terminated, other than for cause or good reason, you leave for good reason, then the rest of your shares will vest. So acceleration, double trigger acceleration is pretty common for the founding team, pretty commonly accepted by the venture capital community for the founding team, and accepted to a certain extent for management. Beyond that, venture capitalists, once you have venture capitalists on your board, they do not want to see anybody below, top tier management getting acceleration terms. Certainly not any anti-dilution clauses for employees. And when management is getting acceleration clauses, it's often 50%, double trigger, or 25%, something like that. Sometimes you see 100%, but there's very often a negotiation between the board of directors and maybe the CEO who might be advocating for something a new hire is asking, or something that management is asking for, the management team.
Is that called a golden parachute?
No, a golden parachute is something that kicks in upon the acquisition. So there are, if in the acquisition a service provider, an employee is going to get more than 3x their annual salary, then you might have a golden parachute. It's not terribly uncommon, and there are ways to cleanse it. You can get a vote of 75% of your stockholders at the time of the acquisition, and if they bless it and say, yes, that's fine, this CEO founder made us all a lot of money, we're very happy for this person to get a golden parachute. That's often the way the issue is solved, but that's what that is.
So
it does require disclosure, though. You have to tell all of your stockholders what you're getting.
So if the founders are bootstrapping the company with a few $100,000, what are the legal documents from the founder's equity perspective and then founder's investment equity? If the founders, they don't have a convertible or a safe notes during the incorporation, can they backdate it for their investment?
I'm not sure I understand the question.
So let us take, if I'm putting, two founders are putting $500,000, right? As a founders, they get 50% each. That is their founder's equity. But they already put in $500,000. They didn't have any agreement as a convertible note or a safe note.
So if you came to me with that issue, I would suggest that you paper it with a convertible or a safe note. So even if you made the investment a while ago, or maybe it comes up in connection with a preferred stock equity round, I would say, okay, you each put $50,000 in at such and such a time. When you raise your first convertible note round, for example, with some friends and family or angels or whatever, we would issue you a note at that time in exchange for repayment of that indebtedness. So you basically convert that indebtedness into a security for that's convertible into the preferred stock of the company.
Okay, thank you.
What if two partners start equal, but halfway through one of them is not really living up to his expectations? What can the other partner do to this guy?
I mean, that's one of the issues that we talked about. That's why it's important to have the vesting schedule. And so down the road, if one of your partner is not really pulling his or her weight, then you have that conversation. Do you really want to be part of this company? And then you maybe separate. And then that's when your vesting schedule is your friend, because then if you are the partner who's doing most of the work, you've not lost half the company to somebody who hasn't put in their fair share.
Mm-hmm. Yeah, I think I would say it's important to have the conversation sooner rather than later to avoid losses in that way. And if you and your partner, if you're not feeling good about the relationship, addressing those issues sooner. Just like any kind of partnership, is usually recommended. The other thing I would note is that putting a separation agreement in place with any key person who's departing is usually a good idea, or any person that might have potential claims against the company. It's best in those situations to get a separation agreement where they're going to sign a release and waiver. You're probably giving them some separation compensation in exchange for that release and waiver. But going ahead and setting out, here are the shares you own in the company. We're paying you, 2 weeks salary or whatever. We're giving you some additional vesting, et cetera, et cetera. Some compensation in exchange for that release and waiver against any claims they have against the company is really important to get if there's a key person leaving, especially if it's kind of a touchy situation. But generally across the board, any key departure or anybody who has claims against the company, you want to put a separation agreement in place.
A question along those lines. Sometimes when people form a venture in the beginning, they might enter into some sort of loose agreement before they actually form the corporation, and something that says we'll figure this out later, and then there'll be standard vesting terms and something like that. And then there might be a falling out with the founder relationship, and someone might leave early. In a situation where the relationship was not clear in the beginning, which is often the case, particularly before people get good counsel, and someone has contributed significant amounts of work for a short period, and then they leave on friendly or unfriendly terms, how do you approach the situation of what that person may or may not be entitled to? Because on the one hand, maybe they never hit a cliff, or there was no equity granted, so they don't actually have any, confirmed rights. But on the other hand, they did contribute to the success of the company, and they weren't paid anything, presumably. So might they be entitled to, some payment for services and value rendered?
Yeah, I think if there's, and this, again, sort of goes into Sherman's area as well, but if somebody has contributed something to the company, it's very important to make sure that the company owns whatever those contributions are. So, if the company hadn't been formed yet, you would want to go and get a confirmatory assignment of IP in connection with forming the company. And you'd probably want to pay the person something, or maybe issue them some shares in exchange for whatever it was that they created that you want to make sure is owned by the company. A lot of these situationships situations are relationship based. So if you've got somebody who's been a key contributor, hasn't hit their vesting cliff, and you want to do the right thing, companies will sometimes waive the vesting cliff and give them vesting up through the, say 9 or 10 months that they were there in recognition of their contributions. Presumably if they're at a point where they've got a vesting cliff in place, hopefully they were also getting a paycheck. So they wouldn't actually have claims against the company. But we absolutely see that where companies want to do the right thing. It's a small community. You don't want to burn bridges or create animosity with good people. So just keeping that in mind and being practical about what the right answer is probably the right thing to do from a business perspective. And then you just need to turn around and make sure you're getting legal documentation to memorialize whatever the agreement is.
There was a question up there. I think you got the mic here.
I have a question. You mentioned early vesting, which is the 83B filing. Is that a right of the employee or the employer? Because I've been in two places. In one, not the early employee, so to speak, after a year or two. What I was told was the first few people, employees, had this early vesting option, whereas when I joined 2 years later, that privilege or perk was not available. So my question is this a right of the employee, or why would the employer deny a late employee early vesting opportunity?
Are you talking about early exercise?
Early vesting, meaning that, for example, when you talk about early vesting, meaning that you can get all your shares exercised even before you have completed 4 years of vesting, let's say, just so as to avoid this AMT tax. So you filed 83B only for that reason.
So I think you're referring to early exercise programs.
Yes.
It's usually the company's decision whether they want to offer early exercise or not. It's generally more complicated for the company to administer, so it's more costly from an administrative perspective, and because it's more sort of technically difficult, it's something that I think a lot of early stage companies opt not to do because of the administrative burden. For a small company, you probably don't have an expert in-house to manage that sort of thing. So I think that's the main reason that companies don't go for it very commonly. Certainly, some of the companies I work with have early exercise by default. That's great for their employees. The main advantage is, if there's an acquisition, if you're early exercising, you're able to start your capital gains holding periods sooner. So you're more likely to be able to take advantage of capital gains rates on a sale as opposed to ordinary income rates. It's usually a decision made at the management level for the company as a whole. And if you have companies that are granting early exercise early on, it may be that, this is feasible when there are only 10 of us, but then once we're at 50 or 100, it's administratively complicated, and we don't have the, we don't have the resources in-house to deal with it. So that would be a common reason not to do it.
Yeah, the administrative complexity that Laura talked about was, if you have a stock option, if an employee leaves, you have 90 days to exercise typically. In a early exercise, you might get the stock, and then the company has 90 days to buy back. And so you have to, make sure that you're doing that. You have to administer that process. And so if your number of employees get bigger, it becomes harder to administer. And also, as the company's value grows, the fewer people might want to early exercise, because you do have to pay the exercise price.
Mm-hmm.
So when the stock price is a penny or a small amount, more people may want to exercise, but as the company's value grows, there might be fewer people who want to actually exercise their stock.
And as the price of the stock goes up as well, the chances that, again, getting into the complexity, the chances that early exercise would cause what we call an ISO-ENSO split, for example, to happen, goes up. So, again, there are sort of other things that could happen to your option. Say you hold an incentive stock option. As soon as you're granted early exercise, the opportunity to early exercise, it's more likely that you'll lose some of that ISO status. That might be more advantageous to you as an individual. That's something that varies person to person. So it isn't necessarily across the board better, as Raj was mentioning as well.
The valuation also, you need to get an external valuer to arrive at your stock price. You can't just say, I think this is the stock price and that's it, because if IRS doesn't accept it, you're going to land up paying taxes on the differential. Is that right?
Yes, with some limited exceptions. There is a method for granting stock without a third-party valuation that I often recommend for very early stage companies. Basically, if you are, once you've gotten preferred stock financing, I would absolutely recommend every company go and have what's called 409A valuation done. But you pay an outside appraiser to come in and value your common stock. The board of directors, approves the price, and options are granted at that price for a year. After a year or any kind of material event, you need to go get a new one. And there's a safe harbor that gives you a safe harbor under the tax code. You can be assured that if an independent appraiser has valued your stock, that the IRS isn't going to come and say, we think it was worth less, or worth more, and you're granting shares below fair market value, which comes with heavy tax penalties. That said, for very early stage companies who don't want to pay the price associated with getting those annual valuations, you can grant restricted stock instead of options, and that works pretty well when you have a small team. The tax consequences are just the same as an incentive stock option, an ISO, so long as an 83B election is filed. The paperwork and complexity is much heavier on the company than incentive stock options. So it's a great option for a very early stage company that has a small number of service providers, before they've gone out and raised a financing round. But once you've got some money in the bank, most companies would switch over to getting outside appraisals, and that would certainly be my recommendation.
Okay, we'll take a last question from there. Are you doing a ICO section after this?
No, we're not.
Okay.
It was just a topic, but we're not doing a.
Okay. So we'll take a last question from there.
You mentioned the kiss of death, and where your partner is not fully committed or hasn't put in full time. My question is with regards to sort of extension of that, when your partner is on a visa at a company, and if you're sort of addressing it as a startup with a consulting agreement, and not using company resources, you're mitigating it where it's sort of in a different domain. The question is, can the startup after fundraising sponsor or you sort of take over that visa process for a partner, for this new employee?
Immigration issues.
Yeah, that is an excellent question. I'm afraid that falls out of my area of expertise. I think if you have a startup company and are able to sponsor an H-1B visa, generally, just because you're an early stage company, doesn't make you different from another company. It, I think could make it harder in the process. But I think, the rules are the same across the board, regardless of the size of the company. Yeah, I'm going to have to punt on that one.
Let me take a crack at
immigration
that.
Expertise.
I'll take a crack at that. I've done a lot of H-1B visas. Now, once you've got your funding, transferring an H-1B to another company is an overnight matter. You file the moment the USICS, moment they get it, you can get the person on your payroll. But if you want to file a new visa, there's that lottery scheme that happens on 1st of April every year. It's a big chance you may or may not get it. More likely than not, you will not. Because there's this thing, then you go to upgrade your person to the master's degree holder. They get a preferential treatment, and then there is a lottery. So it's kind of tricky. I don't know the latest rules because I used to do this a few years ago. And up to that point, I know, yes, transferring was never a problem. A new visa is always a big problem. And if you are not funded, a H-1B visa is reliant on employer sponsoring you. Now, if you don't have an existing organization which has money that can sponsor you, then that becomes a little tricky. But I've been told by one attorney, yes, people on H-1Bs can become co-founders of companies. I'll find out how, and I'll let you guys know over email. Okay?
Thank you.
No. That's what I'm saying. That part, how do they get around that? One attorney who does a large number of they only work on immigration. They do that. He told me it's possible. So I want to find out how is it possible, because of the fact that minimum wage condition is there, the employment condition is there. So what is that thing that a startup can do, to get around this problem? I don't know the latest situations. As I'm saying, I'm a little dated on that. Okay. No, that was the last question. Any other section you want to cover?
Well, just generally, I know the topic was around it was legal and compliance. There are a whole host. If you're getting into a regulated area such as financial services, or whether it's biotech, or whether it is transportation, they're heavily regulated areas, and though that's even at an early stage company, if you're operating in these areas, you want to make sure that you consider that and seek out appropriate counsel to. Because fixing things later could get expensive. That's just
healthcare.
Yeah, healthcare.
Okay, guys, questions that haven't been answered, send it to us by email, and then I will send it around to our eminent panelists and possibly get you an answer. Okay, but it shouldn't be specific to your company only, because then you're getting service for free. That's not the intention. Okay. Anyway, with that, I want to thank our panelists and Raj for moderating. Give them a big hand. And I had to close early because they've told us we got to get out by 9 o'clock. I've got a little cushion time. So if you want to mob the panelists, which typically happens after when we close, you can go right ahead and do it. Thank you very much.
Thank
you.
Thanks.